Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. I normally try to focus on Canadian content, but today I want to talk about the Rittenhouse trial. And that's because it lets us look at a cross-examination, which we can't do with Canadian content because here in Canada, we don't film our trials. There's all sorts of reasons for that, but that's for another video. So a lot of the video content where we can actually look at a cross-examination comes from the United States, and this is a case that's in the news, and quite frankly, it's got an excellent example of a cross-examination in it. So first, what is a cross? Well, we'll start by looking at the other side of things, which is the direct examination. So when you call a witness, you have to conduct what's called a direct examination, which is that you have to ask fairly open-ended questions that don't suggest an answer to the witness, and you're not really, in most circumstances, entitled to attack their credibility. They're your witness. If they're dishonest, why are you calling them? Now, a cross-examination is the opposite of that. Once the person who called that witness is done with them, they hand them over to the other side to basically say, do your best at, challenging this witness. And so the cross-examination is where the other side gets an opportunity to attack the witness or to challenge them. And that isn't always a hostile process. For instance, you might agree that the witness is being truthful and has been diligent and, their evidence should be taken as, as it's given, but you might want to elicit a few more facts than the prosecution or the Crown, in our case, got out. So that's a fairly gentle cross-examination where you're just like, let's elaborate a little bit. But you might be going sort of a step more harshly. You might be saying, listen, you might be trying to be honest, but maybe you're mistaken. You weren't wearing your glasses and it was 60 feet away. So how could you possibly have seen that it was my client? That's a little sort of step up in terms of, aggressiveness and how it's going to feel to the person being cross-examined. But sometimes you have to go and you have to just really flatten a witness's credibility. And what I mean by that is that you might have a witness who is, hostile in the sense of that their position is that your client should be convicted. And they very much want that, or, and you might need to really destroy their credibility. You need the jury or the judge, whoever's trying the case, to, at the end of the day, say, listen, I can't rely on their evidence at all. And you might even need them to go so far as to say, I think this guy is lying. So that's a much, more difficult sort of setup, and it tends to be a little more aggressive, a little more stressful for the witness. And we're going to be looking at the cross-examination of Gage Grosskreutz. I think I've got that right, in the Rittenhouse trial. So that's the individual who was trying to subdue, although he had a firearm in his hand. He's trying to Rittenhouse, and in the process, he gets shot in the bicep and is injured. So he's not fatally wounded, but he did sustain life-changing injuries as a result of this. So he's got some motivation. He doesn't like Rittenhouse. And we're not going to cover the direct examination here. I just am going to try to keep this video as short as possible. So I'm going to give you a little bit of background. His direct, actually, he did really well. He comes off and he says, basically, I'm a pacifist. I wouldn't ever shoot somebody. I'm there as a paramedic. And he really presents himself fairly well. So the issue that the defense has is they're going to need to just destroy this witness. And so there's a few things I want to look at. I'm going to look at sort of some highlights and some key points, just so that we can talk about how that happens in practice. So let's start by just jumping to the beginning, because quite frankly, I think that is a really good place to look, because there's the beginning isn't usually the most important part of a cross-examination, but this one has some different features to it, and so I want to comment on that. So as I said, we'll be looking at just key points here. There's going to be a lot cut out, but let's dive right in here.
All right, cross-exam.
It's just, the jury is watching this. He's walking up with sort of a casual, confident demeanor. he hasn't asked any questions yet, but this is actually kind of an important point uh, for that when you're dealing with this. And this is Chirafisi, the
So, Mr.
defense lawyer.
Grosskreutz, on the morning of the 26th of August, do you remember telling the officer who interviewed you, sometime during the incident, my Gen 4 Glock 27 that has a belt clip attached fell off my waist? Remember that?
I don't recall saying that, no.
Now, let's look at the defense lawyer's demeanor here. He's already dropping some condescension and some scorn, which you're allowed to do. You can be somewhat, you can't swear at a witness, you can't insult them beyond sort of challenging their credibility, but you can do a lot with tone. And right away, we see that this is going to be, he's coming in hot. And that's a risky strategy because you can always sort of start off gentle and then go hot, go aggressive later, but you can't do the reverse. Once you've gone aggressive, you're never going to be able to get back there. So often in a cross-examination, you want to start off gently because that way you can tease out information. You can get the witness while they're still at ease to say things that they might not otherwise when you're coming in aggressively. So when somebody's coming in aggressively like this, what it usually means is that they think they've got the winning cards. They think that they've already got this witness lined up and just ready to serve. And let's see how this goes.
I'm going to show you what has been marked as exhibit number 69 for identification. Do you recognize that document?
I do.
Okay. And that's, if I could be fair, I'm not going to stand by you the whole time, so I'm sorry, but is that your signature?
That is.
Okay. And it appears that that is, it says on 8/25/20 at 11:30 p.m. at 6300 Sheridan Road, and then it goes on a narrative version of your statement. Is that right?
Correct.
Okay.
So here he's pinning down the witness. This is your statement. This is your signature on it. This is a real document because he's about to use this document to challenge the witness to, hammer him on a point. And so he wants to line that up so that the witness can't weasel out and say, oh, no, this is not, I don't know what this document is. I never said those things.
And if I could, toward the end of that large paragraph, you'd agree it says, sometime during the incident, my Gen 4 Glock 27 that had a belt clip attached fell off my waist. Correct?
Correct.
Okay. That's a lie, right?
I wouldn't say that's a lie now.
You didn't take the Glock out of your back here and run with it?
I did.
So it didn't fall off your waist. It was in your hand.
That's correct.
So you would say that's not a lie?
No, I would say it isn't.
Okay, and you told that to multiple officers. Isn't that true?
I don't know.
So a couple of things here. It takes him less than 3 minutes to basically confront this guy with, you lied to the police. That's a real aggressive open. And I love it here because he, if you're going to do that, you need to be able to really pay it off. And I think he does. It's not a situation where he comes in aggressively and it doesn't land. Now, one thing that's really, it's really tough to learn in cross-examination. You want the witness to admit the thing. And in this case, you want the witness to come out and say, yes, I lied about that. And witnesses almost never do. They almost never actually say the thing you want them to say. But you don't need them to. All you need to do is get the jury there. And so when he says that's a lie, and he's like, well, no, that's not a lie. The jury's heard lie. That's in their heads now. And so they're evaluating whether or not that statement was honest. And so, he's saying, oh, you're saying you lost your gun, but weren't you actually running around with it? He doesn't need him to admit that it's a lie. The jury has gotten there already. And it's when you're a sort of junior lawyer, when you're just learning how to do a cross-examination, it's really easy to get sucked into this rabbit hole where you're just doggedly trying to get that out. And, you'd love to see it if you could get it. But the defense lawyer is, and I think, really, he's nailing it in terms of getting it to the jury and then moving on, not getting bogged down, not allowing this witness a chance to breathe.
Same exhibit, sir. The next sentence. I told multiple officers that I dropped my firearm. Right?
Correct.
Okay. Now, you didn't drop your firearm. You were chasing Mr. Rittenhouse with your gun, right?
You're-
Yes. You were chasing him with your gun? Yes?
No.
You didn't chase him down Sheridan Road, pulling your gun, chasing after him. That's a lie. You're saying that didn't happen?
I'm not saying that it didn't happen, but I wasn't chasing the defendant.
You were running after him?
No.
No. Okay.
Now you can see this witness has got this smug expression, and that is very common at the beginning of a cross-examination. You've got a witness who knows you're there to challenge and they haven't taken a few hits yet. They haven't really, taken the hits to the face or the body. They're just, they're still kind of a fresh boxer. So they've got this big grin. They think, oh yeah, I'm going to win this one. And he doesn't realize that he's losing. He doesn't know that yet. My take on this witness, having watched the whole cross-examination, is really that he's a guy who thinks he's smart and thinks he's smarter than he is, and also really values his personal reputation and how he appears. We'll actually see that he's brought people into the courtroom to watch this, people who are affiliated with him, which is a dangerous kind of game. That can actually, I think that's a bad move for a witness who's going to be cross-examined, is to bring people in who who will see it happen. So that is going to make it very easy. It's going to make it easier, rather. I don't want to say that this was easy, because this was actually really brilliant work by the defense lawyer. Again, Corey Chirafisi, I think it is. But he's going to be able to trap him in various ways. And no matter how smart you are, you can't really compete with a defense lawyer who is almost certainly going to be both as smart or smarter. And not necessarily. I mean, you might be really clever, but they're also going to just have the weight of preparation. They're going to know everything you've said better than you know it, because they've been reviewing your statements. You've only got your fading and faulty memory. And that is a recipe for disaster if you're getting cocky, or if you're starting out cocky like this witness is.
Did you ever get charged for not telling the truth to the police about dropping your gun?
No.
Did you ever tell the police in here on this statement that you actually had a firearm in your hand and pointed it at the defendant?
No, I did not.
You never told him you had a gun at all, in terms of as you had an interaction with Mr. Rittenhouse. True?
That is correct.
So he's already sort of laying a foundation here. Keep in mind, as I said, Grosskreutz had a really good direct. He came off really well. So he's coming in on this looking like he's a hero. He's, this great guy. And the defense counsel's got a tough job. They have to not only knock him off this perch, they got to slam him into the mud. So that's what they're working on here, is they really got to crush this guy.
And I know you said you don't know, but Jason Lekowski testified that he picked up that firearm that he believes belonged to you, and there was one in the chamber. Do you dispute that that could be true?
No, I do not.
Now, you had talked about your purpose of being there that evening. You're a member of our Wisconsin Revolution, are you not?
No, I'm not.
You're a member of the People's Revolution?
No, I'm not.
Have you spoken at their rallies?
I haven't won.
And during that rally, have you made statements such as, "Long live the revolution"?
I have.
And you have no affiliation with them, though?
Affiliation, yes.
Okay, there's some of those people in the crowd today, aren't there?
Yes.
So look at that. I mean, you see at the start of that line of questioning, he's going in and he's saying, "Oh, you're a member of this group," and basically he wants to point out that this guy is not there for purely innocent purposes, and that he also has a political axe to grind. So he's going to be pointing out that Grosskreutz is, and this will probably come in the close, but that he's got a political motivation to see a particular result here. So he starts off with, "You're a member of this." "No, I'm not." And you can see the little grin from Grosskreutz as he thinks that he's scored a win there. It's like, "Oh, well, you're sure you've never been a member?" "No, I'm not a member." "But you've given a talk there." "Oh, yeah." And then he goes on to say, not only is, he affiliated, but there's people in the audience from that group. They've come to watch. Again, that's that's bad for the witness for two reasons. One, when he's trying to distance himself from that group, it's going to be real hard when he's able to say, "Yes, I see, those people have come out in support and to watch me." And also, everything he says, they're watching now. So that ups the emotional pressure that's on him. Cross-examination often involves in basically putting somebody under a lot of emotional pressure. You want to catch them and bind them up in their, their dishonesties, if they've been dishonest, such that they're facing such emotional pressure that they start to crack and do what you want. And that's only going to help him if he's got his friends in the audience. That only helps not Grosskreutz. That only helps the defense lawyer here. So that's on Rittenhouse's side, as for assigning out points.
Now, your first statement to Officer, I think it's Birch, on the morning of the 26th. When he's asking you about what happened, if I have this right, you don't explain at all to him as to how you approached Mr. Rittenhouse with your gun, correct?
Am I able to? I don't know.
You don't know?
I don't remember specifically on that document.
Okay.
No.
In
That's
fact,
not going to play well for a
6
jury.
hours after you had been shot, you had a lawyer, right?
Correct.
Okay. And you wanted to stop the interview with the police because you had a lawyer, right?
That is correct.
And this is a civil lawyer, right?
That is one thing that she represents, yes.
Okay.
And he thinks that's a clever answer. Like, he thinks, so I've managed to weasel out on that. That's not a weasel thing. He hasn't successfully dodged anything. The defense lawyer got the information he needed there. This is a civil lawyer. He's contemplating a civil suit. And let's see where the defense counsel's going with this.
She's in court today, right?
Yes, she is.
Okay.
And right there, I got to give him props. Like, he not only would have figured out who that lawyer is, but he's done his homework and been able to identify that who she is and that she's there in court. She really will not have liked that moment where she's called out as being there. Why would she be there? Well, she wants to see how he's doing, because this is going to matter in terms of their chances of prevailing at the civil suit. So she's got every reason to want to see this, but maybe she should have shown up just, or just watched the live stream, or, and had maybe an associate who was less recognizable there in court. I feel like she's probably just, unhappy with that. And I got to give the defense lawyer props. That's a moment that shows his research. You can see also in the background, the prosecutor, the guy with the pin there, he's got an expression of concern on his face because he's already starting to see how this is going.
And I know this wasn't addressed, but you have I'm going to show you Exhibit 16.
And the reason why he's handing the exhibit over to the prosecutor there is just, it's part of trial procedure. It's part of being fair. We do this here in Canada as well. If I'm going to show something to a witness, uh, the other side should know what I'm showing them. They should be aware of what's going on. They should understand it. So that's why they're showing the prosecutor here what they're about to show the witness.
So I'm going to show you what has been marked as exhibit number 62. This is a notice of claim. Is that right?
That is correct.
Okay. Filed on your behalf by your lawyer, right?
That is correct, yes.
So that's a civil suit.
Notice or telling, among others, the city and county of Kenosha that you would like $10 million. True?
That is correct.
Did you read this?
I did.
So are you aware in this document, you never mentioned that you actually possessed a firearm? You know that?
That is correct.
You left that part out, right?
Again, listen to his tone. I mean, it's important because this is a theatrical sort of thing. And it's theatrical both in the sense that he's playing to the jury, but also that he's playing to the witness. The witness needs to hear that as well, just to put the witness into the frame of mind that the defense lawyer wants here, which is basically like, this is incredible, isn't it? Like, you're asking for 10 million and you left out that you had a gun. This is a really, really damaging fact for Grosskreutz. And yeah, defense counsel is really wants to get this out early so that every other time that we hear from Grosskreutz, the jury's going to be thinking, 10 million bucks on the line. What would you do for $10 million? Because I think a lot of people would do a lot of things for that kind of money.
That is correct.
Judge, I would move 62.
Is there objections?
No.
Steve?
You then had, shortly thereafter, I want to say in October, I'm going to show you what is Exhibit 63. You have now filed a lawsuit in federal court. Is that right?
That is correct.
Did you read that?
Yes, I did.
Okay. In that document, you again failed to mention that you possessed a firearm. Is that right?
That is correct.
So in these documents that you are filing with courts, you are leaving out the fact that you had possessed a firearm when you were shot, right?
That is correct.
Okay.
And that is such devastating. Like, that tells everybody watching this that this is weaseling going on, that this is a person who's willing to file court documents and leave out critical details like that. How can we trust this person to be giving us a full and accurate and unbiased account if this is the kind of thing he does?
And this is, so to be fair, this is your testimony today. And how this case turns out has an impact on your ability to try to collect your 10 million, right?
That is correct.
So if he's convicted, if Mr. Rittenhouse is convicted, your chance of getting 10 million bucks is better, right?
I'm not entirely sure how that plays out.
Haven't had any conversations with your lawyer about
Well,
that?
you're not going to ask about conversations with this lawyer.
Okay, fair enough.
So a couple of things that you see there, the jury already heard the question. There's a lot of times where a question gets objected to or, can't be asked. In this case, the first question is, if Rittenhouse is convicted, that makes it more likely that you get the 10 million. Of course it does. The witness's denial here doesn't help him when he says, I don't know that that's how it works. Of course you know. Nobody believes you. And he just has that weasel grin on his face when he responds. I see that on the video. The jury's going to see that 100%. They're going to be on board. Now, there was that question that the judge jumped in and stopped. And the reason why is because defense counsel was asking, what about your conversations with your civil lawyer? Well, those conversations are privileged. discussions between, somebody and their counsel, the court is not going to hear that. So that's why that got shut down.
You're aware that if Mr. Rittenhouse is convicted, your chances of getting the $10 million are better?
I don't have objection on this. I asked and answered, and I don't think he's got a basis to answer that.
Judge,
Well, I sustain on the first ground.
I would move 63.
Objection?
No.
Received.
So I've jumped ahead here a little bit, and what we're going to see is the defense lawyer picking up a thread from before. So keep in mind, there was some intervening time in the actual courtroom, but this is one of the things you can do on cross-examination if you're skilled, is that you can have multiple avenues that you could possibly follow, and you follow them sort of in sequence, in whatever order makes the most sense, but you can pick up lines that you sort of set down before and come back to them. And we're going to see that a little bit here. So let's keep going.
He tells you he's running, and he tells you whatever he tells you. I'm going to the police, or what you think is, he pulled the gun first, and he's running away from you, right? He's running north on Sheridan Road. Yes.
Correct.
And he's running away from where you're standing. True?
Correct.
You at that point pull a firearm out from your belt and begin to chase him. True?
That is not true.
Now, you saw you might have seen the prosecutor sort of go, oh, and make a face behind there. Now, when I hear him say, the defense lawyer here, when I hear him say, I want the picture, I wonder if that was done for a bit of theatrics, just so that the witness sees, I'm getting a picture, I got you, but it might have just been speaking to other people helping him out there. But it could go either way. I don't know what he was thinking, but it raises the question.
I'm going to show you what has been marked as Exhibit 35. You take a peek at that for a second. That's a picture of you, is that right?
On the right-hand side with the blue cap and... Yeah.
You can look there where this is you, right?
Correct.
Okay. And you're digging into your waistband in the back, are you not?
Yes,
That's where your gun is located, is it not?
that's correct.
Okay. Do you see Kyle Rittenhouse in this picture?
I don't think so, no.
Okay. So, if we can be fair here, this isn't him, right?
No, it is not.
Then you don't believe that's him.
I don't believe so, no.
And you agree none of these other people are him either.
I think that's a fair thing to say, yes.
What do you think, to the best of your ability, how far that guy's ahead of you?
It'd be hard to tell, but based on what I can see here, maybe 30 feet?
Okay. So, you believe, based on this, Mr. Rittenhouse is more than 30 feet ahead of you because he's not behind that guy, right?
Yes.
So you can see the witness didn't like agreeing with that. He didn't like agreeing that Rittenhouse was more than 30 feet away. And he probably wouldn't have if it wasn't for the sort of slow progression. You agree that this fact is true? Yeah. And then this is also true. Yeah. And because of that, we know Rittenhouse is, where he is. So again, that's a very careful, planned sort of approach in terms of asking the questions. And the defense lawyer here is clearly incredibly prepared. So he would have gone through all of this sort of planning out that line of attack.
So, he's 30 feet, at least 30 feet ahead of you. You look like at that point you're moving. Is that right?
That is correct.
Okay. So, with him 30 feet ahead of you, running away from you, at that point you pull your firearm and begin to chase him, correct?
No.
You don't begin to chase him?
Nope. No, I do not.
You head in the direction that he's running. Yes?
Correct.
But you just happen to be running in that direction? It has nothing to do with Kyle Rittenhouse running in that direction?
No, it does have to do with the defendant running in that direction, yes.
Okay. So you are trying to chase him down?
No.
And again, I said it before, he doesn't need to get the witness to agree with the chase notion. But putting it this way to him, you know, and you can see he's having a little bit of fun with it and putting on a bit of a show. Like, how can you not say you're chasing him when you are running after him in the same direction because of him with a gun? Like, it just makes the witness look terrible. And so, you don't need to actually get that out. All you need to do is embarrass this guy and make him look like a weasel. And so you can see the other defense lawyer there, Richards, he's got a big smirk on his face. He thought, he enjoyed that moment. And absolutely he should. That's a great moment for them.
You can hear people yelling at that point, get him, get his ass, things like that, right?
That is correct, yes.
Did you hear, there's one that I've heard on this, and I don't know if you've heard it. Cranium that boy. Did you hear that?
I've heard it after the fact. In that moment, I do not recall hearing that, no.
Okay. But you acknowledge you hear get him and get his ass.
Correct, I do.
Okay. So, fair at that point, you believe those people are chasing him down.
Yes, I do.
And I'm going to use the word mob, you use whatever word you want, is getting bigger as they're running, isn't it? More people are joining this.
I think that's a fair thing to say.
So there's this whole mob chasing Rittenhouse down, but he just happens to be going in the same direction.
And you believe, well, tell me if this is true. You were concerned for Kyle Rittenhouse's safety.
Yes, I was.
I love that question, and I'm going to tell you why. This is one of the things when you get an opportunity to do it in cross-examination, it is always nice, which is you feed the witness something that they think makes them look good that damages their position, that damages the chances of conviction if you're defense counsel. So this guy has been trying to portray himself as this hero medic. And so instead of, hey, you're going after him because you want to do Rittenhouse some harm, he's saying you're concerned because maybe this mob is going to hurt him. Well, that helps establish what the defense wants, which is that, Rittenhouse had a reasonable fear for his safety. If you're trying to say, hey, this kid had reason to be scared, well, this guy was scared for him, so why wouldn't he? It's a poison pill wrapped in something where he wants to agree with it so that he can look again. He's trying to get back into that hero role. You can see he's starting to get a little nervous. He doesn't like where this is going, so he's going to jump at that little bit of bait, and he does.
You were concerned because you saw, and I'm going to refer to him as the only way you refer to him, jump kick man. So you see this guy kick him in the face. True?
I do not see Jump Kick Man kick him in the face.
You see him attempt to kick him in the face?
From my perspective, I didn't see any specific motion regarding kicking. But it is fair to say that I did observe Jump Kick Man going over the defendant.
Okay. And
Going over the defendant. Like, that's such an artificial way of answering it. It's clear what he sees, and the defense lawyer is not going to let this go, I don't think.
he's going, if you remember, he's going over the defendant with his foot in the air, correct?
I don't recall that.
You have a picture of
Like, just be honest. It's so many witnesses try to improve the story, and sometimes that's because the story actually is terrible for them. But this sort of thing doesn't happen to you if you walk in and you're honest with what's happening. And that is a big problem here for this witness. He's trying to couch things and trying to get advantage everywhere he thinks he can, and it's not working out for him.
And before I bring it up, to be fair, you're making up ground on Mr. Rittenhouse, correct? As you're running in his direction.
Correct.
Okay, you eventually catch him.
Correct.
Come up to him, right?
Correct.
Okay.
Rittenhouse has a better poker face than the prosecution does. And that's probably because this is a really stressful moment. You can see he's spending a lot of time. I think he's probably mostly in his own head, dealing with his own thoughts here. This sort of dead time is not great for in front of a jury, but it's worse than saying something dumb.
You see that going on, correct?
Correct.
Okay, so if we're being honest with one another, he appears to be trying to kick him in the face, right?
In this photograph, yes.
Okay.
If we're being honest with
How
one
far
another,
away from
which this
when
witness
it's
clearly
going
isn't.
on are you?
I don't recall how far away I was exactly when this action occurred.
You're a matter of feet, right?
I think that's a fair thing to say.
Okay.
Close.
All right, and you're seeing this, so you are having some concern, maybe as a medic or while you're training, that Kyle Rittenhouse is in physical danger. Is that right?
Correct.
Okay. So.
And that's beautiful. I mean, we've got him on the weaseling about the kicking, because how could he have not been able to tell that was a kick if he's seeing it from feet away? That picture is just so clear. And again, he's concerned that Rittenhouse is in physical danger, so why wouldn't Rittenhouse be concerned that Rittenhouse is in physical danger?
And you believe he's in physical danger because he's being attacked, right? That's fair.
It's a fair thing to say, yes.
Okay. So you see this, then you see. Can you bring up the Huber picture, please? Then you see Mr. Then you know you didn't know it then, but you know now that's Anthony Huber, right?
Correct.
Okay. And you saw this happening, right?
Correct.
And it was no more from me to you away probably at that point, true?
I don't recall, but it's probably
That's
fair.
fair?
Yes.
And in fact, you had mentioned to the officers that you even recalled Mr. Huber holding onto the trucks of that skateboard when he was striking you, right?
Correct.
And that, to be fair, as a medic, that concerned you, did it not?
I think anytime that there's a risk of head trauma, it's a risk.
Yeah, no, fair enough. So,
Fair enough, says the defense lawyer, as the witness gives away the farm. Risk of head trauma is a big one. That is a line that the defense lawyer was just, if he doesn't grin openly, I'm sure he was grinning in his heart when he heard that. That's what he really was trying to get to. That's where he would have been trying to take this witness. And the witness is already getting a little more beaten down. He's getting a little more cooperative. So, he's saying, hey, look, this guy's getting smucked in the head with a skateboard. Isn't that kind of concerning? Yeah, he could have been sustaining head trauma. The witness wants to seem smart. He wants to seem a knowledgeable medic. He wants to drop those, that knowledge. And that is right for the defense here. That is a great admission for the defense. So I think we're probably going to be jumping forward a little bit to some other great admissions.
you believe in this picture, one of the reasons you wanted to intervene was you believe that Mr. Rittenhouse was in danger of being seriously hurt, right?
In part, yes.
And you had mentioned to the police that evening that you tried telling Mr. Huber, you just said the guy, but you tried telling the guy to stop hitting him with the skateboard. Is that right?
That is what I put in my statement, yes.
Is that true?
With the benefit of hindsight, I don't believe that to be true, no.
Okay, so when you told that to the police that you told the guy with the skateboard to stop hitting him, that's not correct. That's not true.
That is correct.
Now, your original statement then to the police was, I tried telling the guy to stop hitting me with the skateboard. The guy on the ground then turned over, racked the weapon, and pointed his gun at me and shot me, right?
That is correct, yes.
You omitted the fact that you ran up on him and had a Glock pistol in your hand, right? You left that out.
Correct.
Oh. Yeah.
You think in a case where
Coming
you
back
are
to those
shot,
omissions.
that providing
Or
the
those
police
omissions.
information that you were actually possessing a firearm at the time would be relevant?
I think that's fair, yes.
Okay.
There's no good way to answer that. I mean, either he says, no, it's not relevant, and he's a clear liar, or he says, yes, it is relevant, and, why didn't he tell the police if it's relevant? So those are great questions where basically you can force people to choose between two terrible options. Love it. Great work from the defense lawyer here.
But you didn't think it was relevant to tell him that day, correct?
That's
It's not
okay.
that I didn't think it wasn't relevant. After the defendant had shot me, I had just gotten out of surgery when the Kenosha police officers had arrived and just gone through one of the most traumatic experiences in my life, both emotionally and physically. I had just gotten out of surgery. I had just been sedated. I was on pain meds. So,
Go ahead, I'm sorry, I don't want to interrupt you.
it wouldn't have been a purposeful omission.
So that sounded like a prepared line, but I don't know if the jury will have caught that as a prepared line or not, but to me, that sounded prepared. But he's basically now saying, oh, well, my statements are unreliable because I was hopped up on goofballs at the time.
You were asked at that same statement what you did for work, and you refused to answer that, right?
That is correct.
So you made a conscious decision to not answer that.
That is correct.
You weren't so drugged that you couldn't answer that question, right?
I refused because I was worried for my safety.
My point is that you had a thoughtful process not to answer that. True?
That is correct.
You told this officer specifically what Mr. Rittenhouse was wearing, correct?
That is correct.
You had a thoughtful process, even though you just got out of surgery and were drugged and whatever else was going on, which I understand. You were still able to answer all those questions to the best of your ability, and they were accurate, right?
To the best of my ability, yes.
Okay. So the fact that you failed to mention that you possessed a firearm when you were shot and that you dropped it, were those things that you forgot because of your medication?
I would say not only the medication, but also the traumatic experience that I had just gone through.
And you understand it's the only information that you appear to have forgotten that puts you with a gun directly in front of him, right?
That is correct.
Oh, that is devastating. I mean, he's saying, "Oh, I forgot these key details because I was drugged up." The defense lawyer just tore that to shreds, and that was really well done. You didn't forget anything else, did you? You didn't get anything else wrong. And at that point, the witness has to choose between either, well, I got all this stuff wrong. My statement is just complete garbage, and I've been repeating it today, so my evidence is complete garbage. Or he has to acknowledge that. And that's going to take the jury right back to where they last heard that. Do you remember the context where they last heard about the omissions? That was the lead in to the $10 million. This is a shout out to $10 million. And, that sort of callback is important. You know, you want the jury focused on those questions. So that's what they've got to be thinking here. Uh, and you can just look at him now and consider what he looked like at the start. You can already see the wear on his face. It looks like the under his eyes. It looks like he's gotten bags under his eyes that he didn't have before. All right, I've jumped ahead here. This is a part that really shows the defense lawyer's skill. This is just beautiful. You don't get many moments like this in a career, and you couldn't ask for a better time to have it. In a high-profile trial like this, where you've got, a kid who's the accused, this is the moment to pull out all the stops and, well, let's just see what happens. You may have already seen this on, various things, but let's look at it in context and talk about it just as a moment in cross-examination.
You agree that he runs up to Mr. Rittenhouse and then applies brakes, right?
I do.
Okay, and you'd agree that he's feet meeting you away?
And then it's a fair assessment, yes.
He's advancing on Mr. Rittenhouse, and you'd agree he puts his hands up and Mr. Rittenhouse never fires his gun, correct?
That is correct.
Okay. Now,
Can't argue with the video. Great fact.
you're off screen here at this point, right? You haven't come into the frame yet?
No, I'm not.
Okay. That is, for lack of a better term, this gentleman right here. This is Jump Kick Man, right?
I believe so, yes.
So, you can play it. So, you now see that Jump Kick Man kicked Mr. Rittenhouse in the face, and 2 shots are fired, correct?
With this video, yes.
Okay. You hear that, right?
In the moment, yes, I did hear it.
Okay. Now, if you can see it, we'll play it. I'm not trying to trick it. This is Mr. Huber, correct?
It is hard to see with whatever is blocking.
Play for a second. Okay. That's Mr. Huber, right?
That is correct, yes.
Now, this person here that's just coming into the frame, that's you.
That is correct, yes.
And you are running, correct?
Yes, I was.
Okay. Now, you had originally said that you wanted, you were going to tell Mr. Huber to stop shooting, but now you understand that you didn't say anything. You were just running, whatever word you want. You're moving towards Mr. Rittenhouse, right?
That is correct, yes.
Okay.
Not chasing. No, not chasing.
We just heard a shot, yes?
Correct.
Okay. And to be fair, that you put on the brakes, right? You were running, you then almost stopped in your tracks. Fair enough?
Correct.
Okay. And I don't know if your arms were up at that point, but it looks like you had it protecting your head at that point. Is that fair?
That is correct.
Okay. How far do you think you are away from him at that point, to the best of your ability?
I would say about there, between
Me and you?
you and I, correct.
So, 3 feet?
3 to 5.
Okay.
Pro tip, your arms will not protect you from a bullet, as he learns.
Now, at that point, you have your hands up, right?
Yes, I do.
Now, you probably don't notice him at the time. This guy's holding what looks like a wooden club of some type.
Some sort of wooden object, yes.
Okay. So your hands are up, and at that point, he has not fired at you, correct?
No, he is not.
Okay. It's going to be quick. You'd agree at this point, you are dropping your hands, you are loading your front foot, and you are moving toward Mr. Rittenhouse at that point, true?
Yes.
Okay. So, when you were shot, can you bring up the photo? You'd agree. And now wait, how close do you think you are to him at that point?
3 feet. And if it was 5 feet before, it would. So,
So tell me if I've got the lay of the land. At At this point, you're holding a loaded chambered Glock 27 in your right hand. Yes?
That is correct, yes.
You are advancing on Mr. Rittenhouse, who is seated on his butt, right?
That is correct.
You're moving forward, and your right hand drops down with your gun. Your hands are no longer up, and now the gun is pointed in the direction of Mr. Rittenhouse. Agreed? I'll give you a picture. Maybe that'll help.
He doesn't want to agree to that. He really doesn't. And the defense counsel really, really does want this admission. What I said before about you don't always need it, this is a place where he's, normally I'd say you'd never get it, but it would be real nice. Now, you look, a lot of the fights come out of this witness. This is about 40 minutes into the cross-examination at this stage. He's already managed to catch him in a number of places. He's already, and this is important, the defense lawyer has demonstrated his competence. He's demonstrated that this witness cannot get away with a lie or a misstatement without being caught on it and embarrassed in front of his civil lawyer, in front of his activist friends. So, you can see this witness looks tired. He looks battered. He's having a rough time. He's been taken to a place, like a mental state, where the defense lawyer is going to be better able to secure some of these admissions. And I'm sure that he's not expecting to get anywhere here, but you got to put it out there and suggest it to him, and let's see how he does.
What? What's the next one?
Oh, they're having some video trouble, maybe.
So, Mr. Grosters, I'm going to show you what has been marked as Exhibit 67. That's a photo of you, yes?
Yes.
Okay. That's Mr. Rittenhouse?
Correct.
Okay. Now, you'd agree your firearm is pointed at Mr. Rittenhouse, correct?
Yes.
Okay. And once your firearm is pointed at Mr. Rittenhouse, that's when he fires his gun. Yes?
No.
So, look, I don't want to. Does this look like right now your arm is being shot?
That looks like my bicep being vaporized, yes.
Okay.
And keep in mind, that's going to be a hard picture for this witness to look at, but it's also a hard picture for him to deal with because it's clear, what it shows. And he's just acknowledged that the gun is pointing at Rittenhouse. He could possibly have weaseled and said, listen, I don't think it was quite pointed at him, but then the defense lawyer would have been saying it was swinging in his direction, right? And that would have been a much, harder question for him to avoid there. So I hope I'm not getting too much audio redlining on this one, but let's see what happens here.
And it's being vaporized as you're pointing your gun directly at him. Yes?
Yes.
Okay, so when you were standing 3 to 5 feet from him with your arms up in the air, he never fired, right?
Correct.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct.
That's game, folks. This witness, in terms of his, argument of, that this was anything other than self-defense, that's game. It is such a good admission to elicit, and the defense lawyer couldn't have got there with without all the homework he's done. And not just in this scene, in this little bit here where he's getting him to acknowledge the gun is pointed at, and we see in this picture. And I mean, it really helps that they've got I'm sure that's like a frame grab, but it really helps that they've got such a clear nice, clearly timed picture on that because you can see the spray. Um, he did an excellent job boxing this witness in so that the witness had no other alternative but to say correct at this point. And I, these are the moments that you really hope for in a trial and you almost never see. This is the kind of stuff that you see all the time in TV shows. Matlock has that great moment where he catches the guy in the. Usually that doesn't happen. Usually what you do is you get the witness looking a little sketchy and they're like, I don't know if I can believe this witness. Here, they got him. Like that's beautiful. And then he lets the silence hang. And I got to give credit to whoever's doing the cinematography there because they just zoom in on his on his dead eyes there as he realizes, oh crud, he got me. And I wonder what Rittenhouse is thinking. I would give, you see him nodding here. I'd give just about anything to know what he's thinking at this moment.
You had mentioned that you believe that he was re-racking. I don't know much about guns, but you had mentioned that you believe he was re-racking his gun or something, right?
That is correct, yes.
I mean, I think that lengthy silence is for a couple of reasons. One, just leave him on it, like let him sit and stew in it. And the other is, I think that the defense lawyer was a little surprised that he got him to such a perfect answer. I think he kind of may have had his stride broken just by being so successful. It's like, I didn't expect that. I got to figure out what I'm doing now because I had this whole lengthy thing planned about how I was going to try to get there or try to embarrass you for refusing to answer that question. Yeah.
Now, this is your. This is right.
I'm going to cut off the review here because that was the real showstopper moment. That isn't to say that there's not lots more places where the defense catches this witness, because there are. They keep him on the ropes for a good long time. There's lots of things that they just battered him with. And ultimately, the prosecution's had a few bad days in this trial. This one, it looked to me like they came in that they thought that this guy was going to help them out and maybe, help save their case. That clearly didn't happen. The defense just left him in ruins. His hopes of $10 million? I don't think so. I think that he'll be lucky if he gets paid enough to cover his cab fare on this one. It's just ugly. Lots of people online saw this moment. It's been circulated on TikTok. Viva Frey put this out on Twitter. Lots of people have seen this, but one thing is, as a lawyer, you get a different appreciation of it because you know just how rare it is to get something that perfect. It's just, if you got something like that once every 6 months as a lawyer, you'd be feeling pretty good. That's one of those moments, and it couldn't happen in a better place and to a more deserving guy. So that's, one thing. The other thing is that a lot of a good cross-examination looks effortless. There's a lot of places where, and that's, it has to look effortless. It has to look like every time the witness lies that you're just there to snap down on it. It has to look like it's not taking you any work. It has to be ready to hand. And so what it's easy to miss is just how much work went into this. This is, having prepped these cross-examinations and done cross-examinations, the amount of work that had to have gone into this is just tremendous. For every 5 minutes they've got him up on the stand, they probably spent an hour or more prepping this. It really shows in terms of his delivery. There's not a lot of pauses where he's struggling to look for the next thing. There's some technical things where they're getting something ready, but every time he needs something ready to hand, it's there. And I'm impressed. That's, this is the trial of a decade, and they are not they're not half-assing it. They're really coming out swinging on this one. That cross-examination is just beautiful. Law students should watch that and take notes. It's a good example of well done cross-examination. He gets a lot out of it, and just, it starts out with this witness who you think, when I saw his direct, I thought that this could be trouble. I thought maybe that the defense was going to have to handle this guy with kid gloves and basically say, hey, listen, maybe you're a hero, but because of the chaos and the uncertainty, it wasn't clear what was going on. And so Rittenhouse would have reacted differently. No, by the end of it, they've made this guy out to be a villain, and I think quite effectively and fairly. I mean, they catch him on a whole lot of things. That $10 million thing is brutal. So I really like this as an example. We can't see a lot of this out of Canadian trials. We can get transcripts, but transcripts don't have a lot of the soul of the cross-examination. Those moments where you see the defense lawyer not just rejecting, what's been said, but doing so with that little bit of, snark and condescension that is really essential sometimes to properly, you're telling me you're not chasing him, that kind of thing. So we don't get that here as much, and I think it actually makes it a little more difficult for young lawyers because you don't have this to study. Anyway, let me know in the comments what you think. I mean, I don't know that the prosecution can recover from what's happened in the last few days. I would be very surprised. I'd be quite shocked, actually, at this point, if we see a conviction. I think that that's only likely to happen if Rittenhouse testifies, and if he says something, if the Crown has as good of a day with Rittenhouse testifying as the defense had with Grosskreutz testifying, then yeah, maybe. But I don't see a reason why, assuming Rittenhouse can't be compelled, and I don't believe he can, I don't see any reason why they'd ever put him up on the stand. It would be crazy at this point because I think they've won it. I mean, I don't see that the prosecution can recover from the things that have happened in the last few days. Anyway, just want to thank you for watching. Thank you to my Patreon supporters at the $50 level: Jonathan Wheeler, Canada's National Farms Association, Mike, Kyle Martin, Jean-Guy Toussaint, and the CCFR. I also want to thank the Canadian Shooting Sports Association, also at the $50 level. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Raymond Del McKinnon, Matt Ward, Mark Whittington, Jane Babin Luxer, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Del Salt. Thank you as well to the $10 supporters who will be in the crawl immediately following. Yeah, let me know what you think. I mean, I think this is a great example of what a difficult cross-examination can look like, and can look like when it's done really well. So, I mean, I'm sort of laying my cards out on the table here. I said it a long time ago when the videos initially came out. I said I thought Rittenhouse was going to get acquitted. It's a virtual certainty at this point in my mind. I mean, I could be wrong. Juries do weird things, but I don't think so. Anyway, thank you for watching. I hope this has armed you with knowledge. See you next time.